Thank you, Chairperson. Indeed, I'm very much excited that today I will have an opportunity to address the South African public and the world at large, and to my colleagues in Africa as their president, to engage with them and to take them through what actually transpired, because it's 6.5 years now being the public protector. And I would indicate that I never had peace since I started to work as the public protector. And I think or the cause of all the troubles which you have indicated, Advocate Mpofu, in your opening, touching the untouchables, and I think the real cause being the Democratic Alliance, because as you would know, during my appointment, they were the only party which never supported my appointment. And they were the only party which then after that started with the allegations of me being a spy. And which to this day, they failed to prove, and well, the matter was in court. And also they started in 2017, also then to initiate the process of me coming here. So I think it's good that one is here to just then put things into perspective, and indeed for the public to hear directly from me, because those who have ears will hear, and those who have eyes will see. So, and for them to judge for themselves, because unfortunately they have been told by the most powerful, well, the media, sometimes manufacturing concern and, portraying a narrative which is so wrong. Indeed, I'm happy, though Chairperson, I must indicate, you'll say the statement is long, but we didn't have enough time because, as you know, we were in court on Monday to deal exactly with some of the issues which we've been trying or have been trying since 2017 to bring to the attention of Parliament, and to make sure that Parliament, as the lawmakers, they indeed comply and do things the right way, which I will take you through why I am saying that. So indeed, I'm so excited to be here. And I mean, also deal with the wrong perception that I am delaying the process by not or by raising issues or taking matters to court.
No, thank you very much, Public Protector. I'd like, just as a follow-up, Chairperson, to that, for a case of this size and magnitude and complexity and thousands of pages, for someone like you and me, the question is, where do we start? And they say the answer is usually obvious. You start at the beginning. So I will start a little bit at the beginning, at least of this process, Chair, by reminding us of what we said in the opening statement on the 11th of July, very briefly. It's just an extract from the opening statement, and it's a lead up. Bundle K, page 13, the bundle, people will tell me where it will be found. We don't have to put it up, but we may.
About that, Slot Saber. Just repeat that, she's slow today, more slow.
It's one of those days. Yeah. Okay. No, it's my fault, Chair. I didn't give her the correct. I'll get the proper reference now. But to save time, Chair, I'll just read it in the
I
meantime.
think they're also helping.
Oh, thank you very much. Yes, it will be put up.
Sure.
Item 1, bundle K, page 13. Let's go to, where I want to deal with, I want to make remarks, just a bit, go a little bit up, further up, just so that you move once, further up, okay, no, down, yes, okay, I'll just, that's somewhere in the middle, Chair, where I said, at the instruction of the public protector, of course, I want to make remarks about a few high-level issues, Chairperson. The first is to assure you that we're here to participate in this process, that our participation is, however, under protest because of some of the issues that I'm going to highlight, which I have called major constitutional violations. But we're here and we're going to participate, nevertheless, because we represent a law-abiding citizen and public protector. She has always made it clear that she wants the opportunity to assure this committee and the National Assembly, and indeed the nation, that she is fit and proper, willing and able to discharge her duties as public protector. I said, in that process, she has been accused of all sorts of things, including so-called Stalingrad. The people captured it in a way that is objectionable, which is a term that's used by people who hate the Constitution and try and discourage others from exercising their legal rights, which are in the Constitution. Now, that's a very strange accusation, Chairperson, because the irony is that every time when she raised concerns about this process, she has been proven right, every time. The DA and Ms. Mazzoni and all those people who are in the main sponsors of the motion literally have wanted to do the motion, I think, since the day she took office, if not before. And I'll cut some of the activities in 2017, 2018, but around 2019, there was some intense rush to do this. And the public protector wrote a very long letter to Parliament at the time and explains that, yes, we know that Mr. Steenhuisen, not Mr. Steenhuisenman, as it is put there, that Mr. Steenhuisen and others want her to be removed from office. But there's this small matter of the law, and there are no rules that govern the process for such removal, however overzealous it might be pursued. Eventually, sanity prevailed, and that point that you made was considered, and correctly so, because there was at that stage a judgment that the Constitutional Court in relation to Section 89, that's the Nkandla impeachment we spoke about earlier, which said exactly that, in which I appeared to set the principle that impeachment process must have its own designed rules. The Speaker of this Parliament opposed the application and so on. So, Chair, there we were capturing some of the sentiments that the public protector has touched on. So I just wanted to remind us of that. Now, public protector, those were the words, opening words that you had mandated us to preface this committee with. Can you then explain again why you A, participated, and B, participated under protest even at that stage?
Thank you, Chairperson. Yes, I participated, to put this matter to rest. But then maybe let's start from the beginning. As I indicated that being labeled a spy and the process of then initiating or writing to Parliament. I mean, you read about the long letter which we wrote to the then Speaker, I think, Baleka Mbete, when the DA, after the CX judgment, And whilst after the Gauteng High Court judgment was delivered, then they initiated the process to start saying, I need to account, I need to be removed. I don't know the law. It was all that halabaloo actually in the country, because again, touching the untouchables. Then there were various stages which this process took place, because the then members of the DA, I think it was the start of initiating or wanting to initiate the process. They wrote to the speaker. The matter was dealt with by the Portfolio Committee on Justice originally. That's when they indicated that they wouldn't deal with this matter. This matter should be escalated to the speaker. And, you know, Chairperson and Advocate Mpofu, that's where I wanted this process to be as fair as possible, because at first, remember, they were focusing on me as the public protector. Then later there was a stage where they were saying, no, it's for all members of the Chapter 9 institution. But then firstly, they initiated the process. And I said, but you cannot go ahead and initiate such a process just directly from section 194 of the Constitution. You don't have rules on how this process will be ongoing. But secondly, as well, you cannot communicate every decision which you are making with the media without engaging me. So when you say all the time they were proven wrong, it's because when I spoke about the issue of the rules, then there was that process where they started deliberating on the matter at the committee level, and the committee then said, no, they cannot deal with this matter. It should be escalated to the office of the speaker. Then the speaker initiated the process that there should be drafts of the rules. And then that's where the rules were drafted, but those rules as well it was just a matter of cut and paste, because there was a rush on removing Advocate Busisiwe Mkhwebane from the office, because being labeled all sorts of names. Then I had to initiate that process. And indeed, they drafted the rules.
Thank you. So just to make sure that understand that. So you're saying from about 2017, the DA wanted you to be removed. And it took you and Chairperson, that letter, the long letter she's referring to is dated 5 July 2018. I was not able to establish this morning if it's already on in the bundle, but for current purposes, it doesn't matter. We will upload it in due course, because we're not talking about the content really, we're just talking about its existence. So it took you, the person who doesn't know the law, to advise the Parliament of South Africa that you cannot actually do what the DA wants to do. You need to have rules. And as you say, sanity prevailed, and it was then understood that the process of rulemaking must be done. Right. Then that process then started. Then what happened next?
Yes, as I indicated that the 5 July 2018 letter, then the speaker referred the matter then to the committee. There were various deliberations. It was not only one meeting. I think it would be several meetings, because I think the process took another year to a year, 18 months, deliberating on this matter. Then there was a stage where Mr. Steenhuisen then again writing to the speaker, indicating that we have the draft rules. Hence, I'm saying that was a cut and paste from the original rules which were drafted by Parliament
for the president.
For the president. Yes.
or rather for the impeachment of a president.
Of a president, yes. So then those rules, the way they were drafted, also they were very much questionable, because after the drafting of the rules, then we were never given an opportunity to comment on those.
Mhm.
I will say we, because remember the allegation was it's for the Chapter 9 institutions, and Chapter 9 institutions, for the benefit of South Africans, are the constitutional institutions: Public Protector, Auditor General, Gender Commission, Commission for Religious and Linguistics,
ICASA.
ICASA, and Human Rights Commission, and the IEC.
Mm.
Then I would say we, because we have this forum where I also sit as the public protector of a forum for institutions supporting democracy. So the question was, but this cannot proceed as is, because these rules, I remember even originally it was even including the fact that a member or the head of the Chapter 9 institution might be removed, and you were never given an opportunity to present your side of the story. And I remember one of them being concerned that, I mean, they would say, even when you are incapacitated or you are sick for a longer period, you will just, it was like being summarily removed. The worst part, those rules also didn't include the issue of legal representation. I think they were drafted in such a way that it covers the Chapter 9 institutions. But as you go through the letters and the communications from the DA, you'd see that those rules were drafted specifically for me, because there's where in the letter where it says for the removal of the public protector. And that's another issue of the removal, because this process shouldn't be for the removal. This process should be for the determination of the fitness to perform your responsibilities. Because remember, again, that is still a process. You cannot just, in a constitutional state, just speak about the removal. And I think that's what I've picked up in this committee when they are reading the people for them to take an oath. You know, they will just say the committee for the removal of the public protector. It's not a committee for the removal, it's a committee to determine fitness. Because then if you allow yourself to be labeled that, it means, which I've been saying, or we've been saying, that sometimes I feel as if it's a predetermined process or an outcome. So then after that, the rules were drafted and they were presented to the Speaker, now the 6th administration, Ms. Modise. Then there was that announcement of, Mazone submitted a motion, and the Speaker then announced that they have this motion from Mazone.
Yes, just on that, thank you. So we're now, just to situate it, Chairperson, it's common cause that the rules were passed on the 3rd of December 2019, and the motion, which we now know as the Mazone motion, was generated, sorry, I almost said manufactured, was generated within 72 hours of the adoption of the rules. And on the 6th of December, it was put through. Okay, all that is common cause public protector. But just as a matter of interest, you talk about a historical unfairness. Can you just share with the chairperson and the public and the members how you even got to know about that Mazone motion and how it was processed?
Unfortunately, I discovered, or I found out from the media, the billboard story we were discussing earlier, because I just had the Speaker having issued a statement indicating that there is this motion and it's presented and it's adopted. And that's when further writing back to the Speaker and informing the Speaker about the process and the unfairness of this particular process.
So are you telling the members of the public and the committee that nobody even bothered to just forget about writing, just a phone call or whatever to say, we have a motion here, it's about you, and it has been processed.
No, not at all, because remember, I'm accountable to Parliament on how I use the state resources on the issues of overseeing and performing my responsibilities. I engage a lot with the Justice Portfolio Committee. But besides that, as the Forum for Institutions Supporting Democracy, we engage with the Speaker, and there's an office within the Speaker's office which should be engaging with us regularly. But unfortunately, that was not the case. And I only I discovered when that statement was issued, and I had to then write back to the Speaker. And yeah, that's when we will be dealing with the letter of January 2020.
Yes, all right. So, okay, and the statement you're talking about issued by the Speaker was the media statement.
It was a media statement.
To the public, okay,
yes.
not to you. All right. Okay, Chairperson, again, that's common cause that statement was dated 24th of January, which was a Thursday, I think, if I remember well, because I spoke to the public protector, I think about 24 hours or 48 hours later. Okay, so you see the billboards or the headlines, and of course you then contact legal representatives, and who did not sleep for that weekend. And then on the Monday, the 28th, you caused your legal representatives to write a letter to the Speaker responding to these newspaper headlines. Chair, if I may, can we go to page 660 of the statement, of the Public Protector's statement, which Tsepo will tell us, I think it's bundle H, item 31.7, page 660. It was uploaded last night, or maybe. Okay, you got it. Okay, thanks.
Advocate Mkhwbane, when you give the page numbers on the top, can you also give the type page numbers at the bottom? Because Sepo's having a problem with the top numbers.
Bottom of what? Of the page number?
Yeah. So
No,
just-
unfortunately, this is not. It's not the body of the affidavit. It's an annexure, so it doesn't have a. So go to, okay, let's do it like this then, Tsepo. If you go to the very last page of the statement, the typed statement is 154. And then you'll have BM1, BM2, this is BM3. It's 4 or 5 pages after the 154.
What was your number?
154 is where the Commissioner of Oaths has signed, the last one. And the Commissioner of Oaths signed every page, by the way, yeah. But yes, but so that's the last page where the full signature of the Commissioner of Oaths, and then it's 4 or 5 pages of that BM3.
Let's see if Slow Tsepo is winning.
So Public Protector, while we are waiting there, just to make sure that you didn't amend this affidavit afterwards. You didn't commit forgery.
Advocate Bauer, the mic of Advocate.
Please switch off your mic. Thank you.
No, I didn't. And I think it's very important that we just hold or respect the decorum of this house. And make sure that we treat it as such, because I've taken an oath and I need to make sure that whatever I say is not changed after or somebody else, because if we allow that, somebody else can even change my statement or include things. And I think it's just to protect the integrity of the process.
So, thank you. No, let's not go there. I was just waiting for Tsepo to we'll get to that January at the appropriate time. Yes. So, 28 February, I'm sorry, 28 January 2020. That's the letter. So again, you, the person who doesn't know the law, within 3 days of reading these headlines, you again advise Parliament about its illegal ways. We want, it's a longish, it's not that long, but it's not longer than, rather, it's shorter than the previous one, which was, I think, 25 pages. This one was only 7 pages, Chair, because I was involved in its writing. So your shorter letter, then say that with paragraph 2, I'll just read extracts, Chair. Our client, this is from Sianeho Tennis. Our client is aware that the rules of removal of office bearers in institutions supporting constitutional democracy were adopted on 3 December 2019. And having sought and obtained legal advice, she's of the firm view that these rules are unconstitutional and unlawful, as they amount to a violation of the constitutionally prescribed duty to protect the independence of Chapter 9 institutions. Neither do they adequately provide for aude alteram partem at all in their application and implementation. All in all, the rules are fatally tainted by irrationality and several other breaches of the rule of law. Okay, let's jump to you raise the issue of the involvement of a judge in a process like this, that it was unconstitutional. And then let's jump to paragraph 6. That was an important one. Another free advice from you to the Parliament. You say the even on the DA's version, allegedly occurred long before the adoption of the rules. This purported retrospective application of the rules is in flagrant violation of the rule of law, including the time-tested principle of nulla poena sine lege. And for those who don't know Latin, it simply means there is no punishment without law or without rules. You can't, it's obvious. You must first have a law, and then you must and then you refer to section 1813, we spoke about that. And then you talk at paragraph 9 about pronouncements made by Dr. Matole Motshekga in the committee, which showed that he had preempted the process by referring to your competence. And then you quote at 9.2 Rule 88, which Dr. Motshekga, had breached. That rule says no member may reflect upon the competence or integrity of a judge or a superior court, the holder of a public office in a state institution supporting constitutional democracy referred to in section 194 of the Constitution, that's a person like you, or any other holder of an office other than a member of government whose removal from such office is dependent upon a decision of the House. It's obvious why there is such a rule. And you say that that rule had been breached. Then let's jump to the issue that you've just spoken about now. You say, notwithstanding all of the above, the National Assembly has unlawful, paragraph. Standing all of the above, The National Assembly has unlawfully and out of the blue issued a media statement on 24 January 2020, stating that the Speaker has approved a motion brought by the Democratic Alliance and thereby purporting to initiate proceedings for the removal of the Public Protector. Our instructions are that our client has never ever been accorded the courtesy of being informed about the initiation of this process aimed at her removal from office, let alone being invited to comment thereon. She had to read about it in the media, all in the name of fairness, justice, and Ubuntu. And then you say to the Speaker, you remind her of what was said in the EFF as the Speaker matter, that's paragraph 19, that she, of all people, should know that this is illegal, because what was said in that case was the following, paragraph 55, which is, I think, was high expectation from the judges. It says, although all members of the National Assembly are expected to know the rules of the National Assembly, there is an expectation that the Speaker would know the rules of the National Assembly better than everyone else. And you then said, you please kindly furnish us with a response. And I don't have to bore the committee with the response. The response was dismissive. No, there's nothing wrong with the rules. Go do whatever you want to do. All right. After that, you then did whatever you had to do. What was that?
I think before I say that, Chairperson and SC, because that communication was also trying to say, can we talk? Can we engage on these issues? But yes, it was a dismissive response. Again, going back to those delaying tactics, which I'm blamed for to this day. I was trying to make sure that there's no need for us to go to court because litigation is very expensive. But unfortunately, or again, fortunately for South Africa, is that this constitution is, protecting everyone. Then we had to take the matter to court because we showed them that, and especially in this letter, the issue of not complying to the rule of the Audi Altaram rule. I mean, giving us as Chapter 9 institutions an opportunity to comment on those rules. Secondly, the issue of retrospectivity. That is so wrong. In law, you cannot do that. That you will then have to persecute a person with the law which you've recently crafted. And I think that's what we also told them, you cannot do that. The other issue then was the issue, I don't remember whether we've included the issue of the legal representation, because the rules were saying, no, you cannot be represented, you are legally qualified. But the fact of the matter is, if the rules were not meant for me, what about the other Chapter 9 institutions? Because your Human Rights Commission, well, even your Gender Commission, CRL, they are not legally qualified, those heads of those Chapter 9 institutions. So we had to take the matter to court, all the courts which are there as well, to make sure that there is proper interpretation of what the Constitution and the law is saying. So then the matter was taken to court. If they listened by then, I mean, if you could check, one SC used to say, I mean, counting how many court cases have been to court, as if it's anything wrong. But again, it was trying to bring sense to the lawmakers that they didn't want to, they delayed. Well, finally we had rules, but your rules are so unconstitutional. No, we are proceeding. Then we took the matter to court. And indeed, the court found in our favor to indicate that, yes, you cannot involve the judge. Yes, you cannot it was the issue of legal representation. So again, we were vindicated, but unfortunately then the narration that is perpetuated by the media, because they've always been there, especially mainstream media, instead of reporting properly, educating, making sure that whoever is a South African is properly protected and they understand what this process is all about. And I must say, SC, that I think I understood that, you know, sometimes somebody has to do this or being used as a sacrificial lamb or as, you know, so that this process can be tested. And I'm always been saying, it's not for me. It's for my successors or the generations to come, because we pride ourselves as a country that we have this constitution, the rule of law. But then are we walking the talk? Are we implementing it to the T? And indeed, we took it to court, and the court, again, we succeeded.
Good. Well, that's not what was reported, but for some reason, I'm here now. So I think we did succeed in the in getting you legal representation. Yeah. Okay. Now, I think from what you've just said now, it's important once again to say, because you started by reminding me that these letters were not in the spirit of fighting. It was to say, let's talk, let's not waste taxpayers' money, let's not go to court. These are the flaws in the rules, look at them, and then let's have the impeachment tomorrow if we're going to have it here. But you are forced to go to court. All right. So then you touched on the issue of retrospectivity, which is another advice you are giving to Parliament. And maybe it's time to say something nice about the DA, because the DA looked like it had better lawyers. Yeah. We know that the Parliament said, no, there's nothing wrong with this. But I think the DA said, no, there's a problem. What then happened around the issue of retrospectivity?
You know, they then realized, because at the end of the day, whatever one was advising them on, again, showing that, you know what, do things in a proper way, because if I was somebody else, I would just come up with all the wrong advices, because I said, you cannot apply the rules retrospectively because it was relating to your sub matter, Reserve Bank matter, the Freedom matter,
CX,
the CX matter. And those matters were still before court, and already there were judgments on those matters. Now what they did, they realized that, hey, this is not going to work. Then Mazone withdrew that motion because they realized that it's not compliant to the law, as you are indicating.
You mean Honorable Mazoni?
Yes, Honorable Member Mazoni, Miss Mazoni, yes. So then they withdraw that, and she was the chief whip of the DA. Withdrew that, and within 72 hours, I think, 3 days, they filed a new motion. I'm not sure whether it was 3 days or...
No, it was on the same day.
Same day.
In the morning, it was
yes,
withdrawn.
in the afternoon, it was withdrawn. And unfortunately...
72 minutes, maybe.
Unfortunately, then for the speaker again, instead of also possibly engaging or those who are advising her legally, saying, but you cannot just admit another motion, because they had to find a new issue, and that new issue was possibly being in cahoots with Samuel, because then there was that letter which Samuel wrote to the speaker.
I'll take over from the chair. You mean the Mr. Sipelo Samuel, the second witness, when you say Samuel? Okay.
Yes. So then he wrote to the speaker complaining about being persecuted by me. And by then it was when he realized that I am aware that he assaulted, or we were being sued as an institution, he assaulted a complainant. And that process was the process when I was saying to legal services and the CEO, this is a very, we can't be seen to be doing this. So then the Honorable Mazon, Chief Whip, withdrew that and filed the new motion with those issues of someone. Those were the only new things which she included. But the fact of the matter is those cases were still matters which happened before the rules
Yes.
came into play.
No, fair enough. So, okay, so this was I mean, unless if you're I don't know, 2-year-old child, it was then a clear, at least quiet acceptance of the fact that you can't have retrospective rules. So they had to find a new issue, being Mr. Samuel's so-called affidavit, if we can call it that. Yeah. We've seen some affidavits in this process. All right. Okay, so at least, as we say, the DA saw the light and then they manufactured, quote unquote, or generated the Samuel complaint. Fine. And then they withdrew and replaced the motion with the speed of light. Fine. So that motion then was submitted, Chair, on the 24th, I think, of February. Okay. Then once again, you were faced with a so-called new motion. And then, you, as you say, you went to court, you were forced to go to court, and then the court, at least the High Court here, upheld 2 of your objections, which was the involvement of judges and the lack of legal representation. And once again, the DA, I don't know, like praising them like this, but once again, the DA had better legal advice than Parliament. So the DA then did not appeal against the finding of the Western Cape High Court that you should get legal representation. They only appealed on the other issue of the judge, involvement of judges. But our Parliament of the people fought to the bitter end, up to the Constitutional Court, to say you are not entitled to legal representation. What happened?
Yes, I think again, being a concern that the advice to the Speaker and especially the lawmakers and the ones who are also supposed to be overseeing how the various legal or legislative frameworks are being implemented and also saving the resources of the state. They appealed that. And again, normally I would say it's as if I don't have rights. I must just be left out to hang. And the worst part is that the very same Parliament where I am accounting to, especially always with the annual reports, going there, reporting how one is working. There was nothing stopping them or even the Speaker through this office of the office supporting institutions, supporting democracy, to say, come summon me, sit down. Why is this happening? Why can't this be done? Unfortunately, then they were opposing that I get a legal representation. So, but thanks to the Constitutional Court, again, they brought sanity to that issue that, you know, even a hardened criminal, a serial killer, serial rapist, when they say, I want legal representation, they are afforded that particular opportunity, irrespective of whether this is not a criminal case. But the fact of the matter is they are dealing with the rights of a human being. You know, my mother used to say, "Ngingumundu nami." You know, mundu. Yes. So yes, I think sanity prevailed and we are here.
Thank you very much. Right. Then the Constitutional Court, in a judgment of, actually a unanimous judgment of the Constitutional Court penned by Justice Mkhwbane, then said that you should be accorded not just legal representation, but full legal representation throughout the process. Right. Okay. So again, so you advise them about the rules, they did the rules, but they did them wrongly. You advise them that they've done it wrongly, then they went up to the Constitutional Court and then they lost. And so now the Constitutional Court actually had to itself amend the rules. Particularly the rule 129 AD3, which is the one that said you should have a lawyer who just sits here and says nothing. Right. Fast forward. Then the rules have been cured by the Constitutional Court, thanks to you. And now we are theoretically ready to go. Again, you had to, once the judgment of the Constitutional Court came, it came on the 4th of February, Chairperson, 2022. And Chairperson then gathered his troops. On the 22nd, 20 days later, the troops, and I say that without any disrespect, including Honorable Ngola, the troops were gathered, and it was said that, oh, well, now we can start. The Constitutional Court has told us about the legal representation.
That's in reference to the 36-member committee that I chair.
Yes, another correction, Chair. Yes, otherwise known as the troops. Thank you. That is the 36-member committee of honorable members. Yes, Chair. Right. So that committee then met on the 22nd of February and decided, okay, well, now there's a Concord judgment. Let the games begin. And I'm also just rushing through the common cause stuff, Chair. If I'm putting words in the mouth of the witness, Advocate Bauer will say so. Yeah. Then after the 22nd, the committee then said it was going to finalize its terms of reference.
Just a pause, Advocate Mbofo, Advocate Bauer.
I'm not going to unduly interrupt, but let's not assume that everything is necessarily common cause.
No, that's exactly the point I'm making.
No.
If I stray into
No.
something that's not common cause, then please.
But Advocate Mbofo, I may just leave you to say what you want to say without taking issue, even if it's incorrect, and then pick it up with the witness when it's our turn,
fair enough.
rather
Thanks.
than seek to interject. All I'm suggesting is, if I'm not raising an objection, don't naturally assume it's common cause.
No, I don't. I think I'm addressing a different issue. I'm saying I'm not necessarily that it's common cause, but I'm saying if I put a leading question or if I give evidence, as it were, about dates, if it's common cause, then unless if I stray into disputed stuff, then please raise it here. Okay. So
You just put back your mic. Thank you, Advocate Mkhwbane.
yes, thank you, Chair. Yeah. So I was just, I think the Chair understood, saying that if I fill in dates and so on, unless if it's contentious, right? So I was saying, okay, then the committee meets. The committee, this is all common cause. The committee decides that it must adopt terms of reference. The committee decides that at some stage it will be appointing evidence leaders and so on, all well and good. Because the committee had been suspended, well, let's put it, had voluntarily suspended its work.
That's very correct.
Yes,
that way.
the committee had voluntarily suspended its work at the advice of acting Speaker Tsenodi, who really has been probably the best voice of reason throughout this breath of fresh air. When they were waiting for the Constitutional Court judgment, he advised the Chair, and the Chair agreed. I don't know if he agreed willingly or kicking and screaming, but he agreed to suspend the process. Right, and then it was then unsuspended duly because the Concord judgment was out. Okay, so, and Chair, I'm doing this really also to help other people who are not familiar as you and I with the process, just to fill the gaps. Anyway, that's fine, that's February. March, come March, the 10th of March, the Speaker of Parliament writes to the President and says, the committee started on the 22nd, blank, 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 without saying what that letter was for. And then on the 17th of March, the President says, oh, I got this letter. Tell me why I should not suspend you in terms of 194.3A. Then again, you write letters, let's not go to court, let's be amicable, and so on and so on. Rejected. What happened next?
What I would say is that, I mean, you're raising the issue of the Deputy Speaker. Normally, the Deputy Speaker is responsible for supporting and overseeing the operations of the constitutional institutions, especially Chapter 9 institutions. So I must indicate that I think even the other Chapter 9 institutions had, when they met with him, they raised their concerns and the challenges. I think that's when he also realized that, I think, you know, let's just focus on what the law is saying. Let's allow the process to be taken to court. Let's wait instead of just proceeding as if there's no tomorrow. So then, indeed, then the Speaker wrote to the President, and then the President started the process of writing to me. I think that was what triggered the letter which was written by the President. So, and I think the previous Speaker, Ms. Mudise, Honorable Mudise, well, he was the Honorable Mudise, member of the House. Chairperson is calling me to order here. Well, who is going to call me? But then they wrote informing the President of what is transpiring. But then the second letter by the Honorable Speaker, Mapisa Ngagule, then was like, now it means we can, in a way, start the Section 194 process. So that's when then I received the letter from the President asking why I should not be suspended or give reasons for that. Then the process started again, where we wrote back to the President, trying to show the President that, okay, let's engage on these issues. Again, the Speaker, can we communicate on these issues? But that fell into deaf ears again. What else to do? Go back to the courts. I think there was then part A of our application where we were trying to interdict the process. And I think interdicting the process, again, it's not an ideal process, but I think if we can reach a point where issues are deliberated on, we agree and avoid state organs litigating against each other, because at the end of the day, it's the taxpayers' money, and that fell into deaf ears, and then we had to go back to court.
Thank you. Yes, again, to speed things up, you're right.
Maybe just before you proceed to
yes,
us,
Chairperson.
I want to take a break, but if I don't, I'll be in trouble, and you know from where I'll be in
I
trouble.
know, Chair. I know. I support you, Chair.
I want us to take a 10-minute break. We'll resume after 10 minutes.
Thank you, Chairperson.
Thanks.